Hello all. So today is the fifth and second last session of ongoing playlist, which is law journal and carries 10 marks of theory as per existing IBBI syllabus, and with effect from 1st July 2022 it will carry 9 marks for theory. So very scoring and interesting topic. So in today's session, fifth session, we are going to cover law of evidence, SARFAESI Act and Banking Regulation Act, and their salient feature which are relevant for IBBI examination purpose. This is the full syllabus as for IBBI exam, which get 10 marks or 9 marks with effect from 1st July 2022. Point number: Indian legal system, government, law of contract, tort, law of arbitration, auction. So these parts we have already done. In today's session we are going to cover law of evidence and SARFAESI action and Banking Regulation Act, and in next session we are going to cover about IBC Companies Act and Registered Valuers Rule 2017. So law of evidence 1875. So first important concept of law of evidence is burden of proof. So what does it mean? When a person is bound to prove the existence of an effect, it is said that the burden of proof lies on that person. So let me just repeat. When a person is bound to prove the existence of an effect, if I am the person and I am bound to prove an effect, so in that case it is said that the burden of proof lies on me. So the next important question arises is that on whom the burden of proof lies as per Evidence Act. The burden of proof lies on the party who will fail in a suit if no evidence is being produced by either parties. If you and me are into a dispute and no evidence is going to be produced in that case, and say if I am going to lose the case, then the burden of proof will fall on me as a losing party. So let us understand this concept with the help of an example. For example, A sues B for money due on a bond. The execution of the bond is admitted, but B says that it was obtained by fraud, which A denies. So if no evidence was given by either side, A would succeed as the bond is not disputed and fraud is not proved. The burden of proof lies on the losing party, which is B in this case. So sometimes a case study on 1 mark theory or a case study may come out of this concept only, that on whom the burden of proof will lie. A case scenario or case study might be given by the examiner, and examiner may ask you the burden of proof will lie on Ram, Sham, maybe two three parties may be involved into that case. Presumptions, that is also an important concept of Evidence Act, which is presumptions. A presumption in law means a presumption of law means inferences which are concluded by the court with respect to existence of certain facts. It can be of following three types. Please remember these three types. Theory question, mark theory question may come out of this slide also. So first type of presumption is may presume, second type is shall presume, third type of presumption is conclusive proof. So what does that mean? May presume, as per Evidence Act, wherever the court may presume a fact, either treated it as a proved unless and until it is disappeared, or may call proof of it. So these type of presumptions fall under category of may presume. Second set of presumption is shall presume, as per Evidence Act, where court shall presume a fact as proved fact. So here it was presumed or call for a proof, but here it shall presume the fact as a proved fact unless until it is disapproved. So here evidence will not be required. Conclusive proof. Conclusive proof are presumptions which cannot be changed by any additional evidence or argument. So even if new argument or document is provided, that statement will not get changed. If one fact is declared by the Act as conclusive proof of another, the court shall, on production of such fact, shall presume the other fact as proved and shall not allow evidence against it. So in this conclusive proof, even evidence will not work. So here evidence may be asked, here no evidence is asked. Here even if evidence is produced, then even then it will not be accepted contradictory. So next important topic for IBBI syllabus is SARFAESI Act 2002. Full form of SARFAESI, please remember from examination perspective: Securitization and Reconstruction of the Financial Assets and Enforcement of Security Interest Act 2002. One mark theory question may come out of this full definition slide. So there are few key terms as per SARFAESI Act, like authorized officer, demand notice, approved valuer. These three important terms are there from examination perspective. What is authorized officer? Officer of chief manager rank or above of bank is authorized to exercise the rights of secured creditor under the Act. So any officer of CM, which is scale 4 in government banks or above, is authorized to act as a authorized officer as per the SARFAESI Act, and he or she can take action against secured creditor and as per the SARFAESI Act. Please remember this point, that who is vested with the powers under SARFAESI Act. Next important point is demand notice. It is a written notice sent by the secured creditor under section 13(2) of the Act. This is very important section, please remember. Demand notice is being sent under section 13(2). It is also called tirado in simple parlance language. So 13(2) of the SARFAESI Act. Approved valuer, as per SARFAESI Act, the approved definition of approved valuer is valuer registered under section 34 AB of Wealth Tax Act. Till now IBBI registration is not required for doing valuation for cases of properties under SARFAESI Act. In future it may be required, but as of now, till now, as per SARFAESI Act, registered valuers who are registered with 34 under section 34 AB of Wealth Tax Act 1957 and approved by board of directors of the bank can do valuation of the property of the cases which are under SARFAESI action of the bank. Possession of movable asset. Please understand this process also. If amount mentioned in demand notice is not paid by the borrower within the time specified in the notice, minimum 60 days, the authorized officer shall take possession of the movable property in presence of two witnesses. So movable asset like car, for example. Then authorized officer shall prepare a panchnama and give a copy of it to the borrower. So these are the two steps. So how to do valuation of movable secured asset? After taking possession, then valuation will be required. So after taking possession, the authorized officer shall obtain estimated value of the movable assets and if considered necessary, fix in consultation with the secured creditor the reserve price of the asset under possession. So after taking valuation of the movable asset, next step is sale of movable asset. So the authorized officer shall serve a 30 days notice to the borrower for sale of the movable assets and thereafter can sell the movable asset by any of the following ways as under. So first method is by obtaining quotation from the parties dealing in secured assets or otherwise interested in buying of such assets. Second option is that by inviting tenders from public or by holding public auction including e-auction, third option, and or by private treaty. So these are the four methods. Either of four methods can be used by authorized officer to sell the movable asset under SARFAESI Act. So next is sale of immovable asset. If borrower doesn't clear, immovable asset is like property, land, building, factory. So if borrower doesn't clear the dues, the authorized officer shall paste a possession notice outside the door of the property. So this is first step. Then within 7 days, such possession notice shall be published in two leading newspapers. Please note down this point. One of these two newspapers should be vernacular language, that is local language. If we are taking property possession in Tamil Nadu, so notice in local language, which is Tamil, need to be published, having sufficient circulation in that locality. Third step is authorized officer shall obtain valuation of the property from an approved valuer and shall fix a reserve price of it. He may consult the borrower for fixing reserve price if he feels so. Then authorized officer may sell the whole or any part of the property. Please note down this point also. Authorized officer can sell entire property or part of the property by any of the following methods, which is by obtaining quotations from the person dealing with similar secured assets or otherwise interested in buying such assets, or second option is that by inviting tenders from public or by holding auction including e-auction or by private treaty. Please note that before selling, the authorized officer shall serve 30 days notice to the borrower. That is mandatory as per SARFAESI Act. And the last topic for today's session is Banking Regulation Act 1949. So as per section 5N, this is the only part of the syllabus. This section is covered by IBBI syllabus. Full act is not required to be done. Please have an idea of this section only from examination purpose. So as per section 5N of BR Act, definition of secured loan and unsecured loan is given. So what does secured loan mean? A secured loan is a loan made of security of asset, the market value of which is not at any time less than the amount of the loan. So a loan against which is secured by an asset, and market value of that asset should always be more than the outstanding of such a loan. That is called secured loan as per section 5(1) of BR Act. Unsecured loan, if loan amount at any point in time supersede the value of the property, the loan is treated as unsecured. So if outstanding loan balance is more than market value of the property, present market value of the property, then it is treated as unsecured. So that's all in today's session. Thank you for watching. If you have not subscribed to the channel till now, please subscribe to it and click on the bell icon for upcoming session. So in next session, which is going to be final session of ongoing series General Law, we are going to discuss about salient features of IBC, Insolvency and Bankruptcy Code 2016, which are relevant for IBBI examination purpose. We'll also discuss about section 192 to 231, 232, 233, 231, 232, 247 and 281, which are mentioned in IBBI syllabus of Companies Act. Number 3, we're also going to discuss about salient features of companies valuation, registered valuer and valuation rules 2017, and we'll see what are the requirements of becoming a registered valuer as per IBBI guidelines. Thank you.